since 1987. I've been here a while. I've always handled divorce cases, domestic relations cases, primarily in Lancaster County and the surrounding counties. But I do want to thank all of you who are participating today. We hope to provide some useful information to those of you who might be new to the area of divorce law, or to those of you who just want some basic information about this subject. I also want to give a big thank you to the Omaha Community Foundation. They have provided legal aid with a generous grant to help the victims of domestic violence in the Omaha area. Most of that funding from that grant is to provide direct assistance to our clients. That can be in the form of advice, brief service, limited scope, assisted pro se, or full direct personal representation. Our longtime Omaha family law attorney, Elaine D'Amato, and her paralegal, Stephanie Watton, provide most of that legal assistance. And Elaine and Stephanie really do a fantastic job out of our Omaha office. Elaine was going to be part of the presentation today, but unfortunately she is out of town. Although the Omaha Community Foundation grant primarily funds Elaine and Stephanie's work with clients in the Omaha area, a small part of the grant does include a requirement that legal aid offer some continuing legal education to people who assist victims of domestic violence. Last year, we offered 2 webinars on protection order cases. And this year, our first webinar is today's presentation on divorce basics. So that is why we are all here today. Our hope is that this information will be used by some of you or all of you to assist clients in need, particularly victims of domestic violence. So again, many thanks to the Omaha Community Foundation for that generous grant. A few housekeeping matters. Today's webinar will get you 1 hour of continuing legal education credit. And I do think it is great to get started on those hours early in the year. So kudos to all of you who are going to get off to such a fast start on your 2024 CLE requirements. A reminder that this CLE does not count as ethics. It is a general CLE event. It will count as 1 hour of continuing legal education. And the activity number for today is 258377. Again, 258377. We can probably post that in the chat just to make sure that anyone who logs on late will be sure to get that activity number. Finally, I will say that many people here at Legal Aid have worked on this webinar and on this grant. As I mentioned, Elaine D'Amato, Stephanie Watton out of the Omaha office have played vital roles in fulfilling the terms of the grant. They are actually representing the domestic abuse victims in the Omaha area, which is what this grant is all about. But also Jenna Heineck, our communications manager, has done a fantastic job making all of Legal Aid's communications, including this webinar, very professional. And our chief of legal strategy, Jen Gahn, has also worked very hard on this grant with the Omaha Community Foundation. But the person doing most of the work on this webinar today is my longtime colleague, Mark Bestel. Mark is a supervising attorney at Legal Aid of Nebraska, where he represents clients in a variety of practice areas. He received both his BS and his JD from the University of Nebraska. He's a member of the family law and appellate law sections of the Nebraska State Bar Association. He's the person I turn to when I have questions. So, Mark, I will turn things over to you.
All right. Well, I am, Pat said, an attorney at Legal Aid. I'm going to share my screen and pull up a PowerPoint presentation here. And I believe can people see that? Is that showing up?
Yep, we can see it.
All right, good. So first hurdle out of the way, PowerPoint is working. I am not the most computer savvy person that you will meet in the practice of law. So anyway, we've got that going, and I will tell you this. This is I created this PowerPoint presentation a few years ago, maybe I don't know, longer than that ago, and I guess before COVID, for a presentation for a CLE for the Volunteer Lawyers Project at the bar. And so this comes from the perspective that I am that you know nothing about any of this. So if it sounds oversimplified, or that that you know some of this already, that's good. But this was for created to help people that were volunteering to help with the family law cases that did not have much experience in doing these cases. And so just sort of how to just even get started. And I based this then also on like a sort of a training I had created at Legal Aid for new attorneys. There's just sort of a reference to how to get started with your first divorce case. So that's what this is about. It's not going to get into too fine of minutia of some of the crazy and wonderful and fun legal problems that come up in family law. This is really just about the mechanics and the basics of divorce, legal separation, and annulment. So I am going to start. I know that there were some questions sent ahead of time, and we will answer questions as they come up, or at the end, or however, whatever works best. I probably won't notice if there's questions that are sent during the presentation, because I'll be looking at the presentation. So divorce basics, divorce, legal separation, and annulment proceedings. Here we go. How do I make it move? There we go. Divorce. That's the first one. So who may seek divorce in Nebraska? That's your starting point. If they come to you and they want to get a divorce here in Nebraska, there are rules about who can obtain a divorce in the state of Nebraska. And the statute that tells you who may do that is 42-349. And chapter 42 is the households and family statutes, or chapter. Used to be called husband and wife. They changed that a few years ago to reflect more modern ideas of that. And so these are sort of the basic requirements to file a divorce in the state of Nebraska. Main thing is the residency requirement. In order to file a divorce in the state of Nebraska, somebody has to be a resident here. You want either the plaintiff or the defendant, person filing the case or the person being filed against. So somebody who lives in Iowa and their spouse that they're separated from lives in Nebraska, the person in Iowa may file in the state of Nebraska, so long as the residency requirement is met by the other party. And that residency requirement is a 1 year of residence prior to the filing of the complaint. So they moved, 360 days they've been in Nebraska and you file the complaint, that does not meet the residency requirement. There have been case laws that have sort of touched on this idea of what a bona fide intent of making Nebraska your permanent home is. It's not much of a burden or hurdle to get over to show that that this is your intent to make this your permanent home. So that's not usually an issue, but the timing is really the issue. How long has somebody been here? The only real exception to that residency requirement is if the parties were married in Nebraska and then less than a year has gone by and they weren't a resident at the time. They just moved here in July, got married in August, September, one of the newlyweds decides this is not for them. They leave, and then you can still file here. So as long as you've been living here since the solemnization or the time of the marriage here in Nebraska, then you can get around that 1 year residency requirement. It's I've not had that come up in my practice at all, where that has happened. I've had it come up where they want to get divorced right away, but not where they hadn't already lived here for that period of time. And I think that if this is the case, then if that number 3 there is what's happening in your case, you need to allege that in your complaint. Just like you need to allege that somebody's been here for a year, like number 2 there, you need to put that into your complaint. And if not, if you're relying on the fact that they were married here but have lived here less than a year, and when somebody is still living here, then you would need to allege that in your complaint as well. This requirement, unlike a lot of things in court, cannot be waived. It's a jurisdictional requirement, and the court just cannot do anything if that residency requirement is not met. So that's an important aspect, and like questions that you should ask of your client, when you're wanting to consider taking their case and bring a dissolution action. All right, moving on. Where do you file the complaint? Well, that's a good question too, I think. And there's a statute that tells you that. And I'll just say, when I first started practicing law, I can say decades ago, my first boss, I would go to him with questions and he would say, did you read the statute? He wouldn't answer me. He would just say, did you read the statute? And that was the best advice he ever gave me, because usually I could find my answer in the statutes about what I was wondering about. And it's amazing what all is there. They actually do at the legislature think of a lot of things when it comes to practicing law and these lawsuits and what you need to do. So there is usually an answer there. So look there first, and here is what you do. Where do you file the complaint for dissolution? 43 dash, oh no, that should be, that's a typo. That should be, is that 40? Yeah, that should be 4243. So I'm going to go back. I'll change that. I missed that. That up there where it says 43-348, that is wrong. I mean, it's 42. So usually civil lawsuits in Nebraska, you get somebody rear ends somebody, and the victim of the accident wants to sue the driver that caused the accident. You can kind of file that wherever you want. It doesn't have to be where somebody lives, doesn't have to be where the accident occurs. And of course, then you can fight over where the most convenient place to have it is once it's on file and it may be moved. But generally, the state district courts have general jurisdiction over civil actions, but not in family law cases. In family law cases, there is usually some venue requirement, and they're different from type of case to type of case. So we're not going to, this presentation doesn't get into paternity actions of unmarried parents, and so those venue requirements are different than they are here. But one of the parties has to live in the county where the district court is, where the case is filed. That is the venue requirement for a dissolution. It can be, doesn't have to be the plaintiff. It can be where the defendant lives. Again, because the plaintiff could live out of state. They want to bring the action here in divorce because maybe the other state doesn't have jurisdiction, but Nebraska would. So they can file it where the defendant lives, and that's good. And one of the other things is that you can request the matter be heard by a county court judge. I believe this provision was done because some of the more in the rural communities, the district court judges move around from county to county and cover a little bit more area, and maybe are only in like say Clay County. The district court maybe is only there once or twice a month, and so it may be harder to get something just like maybe a simple divorce done quickly in those types of situations. So you can request a county court judge do it, although if you do that, the matter is still a district court case with a district court case number, but that is allowed by statute. to request county court judge to hear the case. And I don't know if that's why. It just makes sense that would be why you can do that, and why you can request a county court judge. And I know people that have done that for those reasons. All right, so now I make it go forward one here. What do you file when you're starting out a case? What all needs to be filed at the same time? This is a list of what you need to file. So you need to file the complaint for dissolution of marriage, and that we're referencing section 40, statute 42, 353. That tells you what that complaint needs to say, and what you need, where you need to file it. So though you can look up, read that statute when you're getting ready to file your first complaint for dissolution of action. Make sure you comply with what that statute says. The other thing you need to do is either pay the filing fees or file a motion or application to proceed in form of papyrus, which would waive the costs of the filing fees and the costs of service. Filing fees are $162. Now here at Legal Aid, where I work, I mean, I've been at Legal Aid for 17 years. I've had one case where we've always sought to proceed in form of papyrus for my clients because they are poor people that qualify for our services. And I've had one case where that was denied at one time, but that's it. There's the one time. And so I don't usually have to worry about getting the filing fees because our clients, you know, I would say always qualify to have the fees waived, because we do a good job of making sure our clients qualify for our services. But you do need to file that or nothing happens, either the fee or the motion. And what you include with your motion is a motion to proceed in form of papyrus and an affidavit of your client stating out all the reasons why they can't afford it. I usually put in things like if they're have government benefits, what government benefits they are qualified or that they're receiving. I remember one time I had the judge set a hearing on the issue of my client's in form of papyrus status because I think the county objected to it. And we had the hearing and the judge asked me what SNAP benefits were. I just put in for my client's affidavit, I received, you know, $350 or whatever it was in SNAP benefits. And the judge here in Lincoln at the time did not know what SNAP benefits were, which surprised me. But so from now on, whenever I use that phrase, I put in formerly known as food stamps. I think most judges should know what that means. But I was quite taken aback that there was a sitting judge that did not know what that meant. Anyway, that's off track here. And then a proposed order granting the client the leave to proceed without paying those costs and fees. And if the judge, for whatever reason, disagrees with that, the judge can set it for hearing. I think, and the county can object since it's coming out of the county's coffers, I guess, to pay these costs if they for some reason feel that there is a reason, and I can't even remember why the county had picked that case that I had filed to object to, but that's what happened there. Other thing you must file is a confidential document, the social security numbers, dates of birth, and gender information, and you provide that for the parties and any minor children. And then you can't access that through justice once that's filed. That's not something that's visible. It's considered a confidential document, as is the vital statistics information. That's a worksheet. And I think that might be when there's that's a worksheet created by the state of Nebraska that you complete. And I think they use that then to establish whether there needs to be a child support account set up or to be expecting an order for child support or not. And also to then issue, just have the record of whether there's a marriage or a divorce. your praecipe for a summons to have the other party served, or a voluntary appearance in lieu of that. And there's interesting case law about the voluntary appearance, and there was a case that came out where the voluntary appearance had been signed quite some time before the action was filed, and so that person that had signed it was trying to say that was invalid, but turned out, I believe, if I remember right, it's been a few years now, and I haven't looked at that in a while, that it turned out to be a valid, because it's always going to be signed first if you file it at the same time that you're filing the lawsuit. All right. Perfection of service. This is just from the general civil procedures in the statutes. So this isn't specific to divorce, but this is what you do. Action is commenced on the day the complaint is filed. Each defendant in the action must be properly served within 180 days of commencement of the action. And in a divorce case, the other side has to be personally served. So that means sheriff, and if that doesn't work, then you need to seek leave of the court to serve by some other means before you go ahead and attempt those other means, like publication or constable service. And then, so if somebody isn't served within 180 days, then by operation of law, that case is dismissed. And it's amazing how often I've run up against this where judges don't seem to know that or don't recognize that. I've filed a case and they'll say there's an active, I'll get the district court clerk will say there's already an active divorce, and I will say, no, there isn't. That was filed a year ago and nobody was ever served. And it's always, I don't understand. Somebody needs to do some training somewhere for the clerks and the judges, because they just they don't exist anymore. They're dismissed. And it would be improper to enter orders or do anything in those cases. All right. Parenting Act. Now we've been doing the Parenting Act for quite a while at this point. I can't remember when that started. Was that 2008 maybe? That began, and it was sort of a big deal at the time. Everybody was very opinionated about whether this would be beneficial, and I think a lot of us feel like it hasn't really. People that are going to fight about things are going to fight about things, and people that are going to agree to things are going to agree to things. At least in my experience, that has been the case. But parenting plans are a great thing. I appreciate the parenting plans, but some of the other aspects of the Parenting Act, I don't like. The mediation aspect, I just don't know if that thing. I'll just move on with that. But those are the statutes there that tell you why your clients need to do these things. They need to take a parenting class. If there's kids involved, obviously they don't have to do any of this stuff. If there aren't any children, this is the Parenting Act. So the parenting class is required, the basic level parenting class. There's online parenting classes. Those have the one at the university that the UNL provides, the online class, I think can be reduced down to about $20 if they're income qualified. So it's relatively cheap. Those for, neither the cost of the parenting class nor the cost of mediation are covered by an order granting informa pauperis. Those are costs your client will have to pay. And so I recommend my clients to use the UNL online class, because I think that is probably at least the cheapest one I'm aware of. And it, qualifies. It's court approved to be used and filed as their parenting class. Parenting plan, that is required. And those statutes tell you what needs to be in the parenting plan, what the parenting plan should encompass. And of course, that's going to state who has the legal custody, whether it's joint custody, legal custody, or one of parent has legal custody. It's going to state where the children live, who is the primary residence for the children. It's going to identify and state any of the specified parenting time for the parties and the specified holidays that each parties get in the course of a year, and all of that stuff. So, and those have been really great to have a parenting plan just outside of a decree that sets, just lists what all those things are. Mediation, though, those are the statutes that talk about mediation. And my clients generally can't afford much by way of mediation, so we often refer clients to the mediation center in Lincoln that will work with poor people on sort of a sliding fee scale, so that they can better afford it. But it is, as I said, those are costs that the client must pay for. They are not covered by an informa pauperis order, unfortunately. All right, in Nebraska, you want to get divorced, once you file and get somebody served, you have to wait 60 days before the court will have a hearing. So the court can't even have the hearing and then wait and sign the order when the 60 days is up. You can't have a hearing until 60 days after you've perfected service, whether that's the filing of a voluntary appearance or personal service by a sheriff, whatever that date is. 60 days later, that's when you can get in for a hearing for a final divorce decree, even if it's all settled. You can't do it any sooner than that. Now, in reality, I don't think I've, even in cases where everything's been settled, I've ever gotten in, on the 61st day. I mean, it don't happen that quickly. But that is the rule. And local rules. So wherever you're practicing law, your district court is gonna have local rules about how to do these things, and some of them are fairly family law. Local rules can be fairly extensive depending on where you are practicing or where the case is, and can include anything about the exchange of information prior to trial and all of that, and how to go about getting a hearing, what you need to do. So learn those local rules or review those local rules each time you have a case, particularly somewhere maybe where you haven't done one of these cases before. You usually practice in Lancaster County, where I am, and suddenly you've got a case in Seward or York County. Review the local rules. You can find those on the external rules link at the Nebraska Supreme Court website, and just click down to whichever judicial district it is, and there you go. You'll find those rules. So I think this is the last slide for divorce, then we'll move into the other aspects of this. So this has to do with, this case is a great case, and because I think some of us had sort of suspected that this was the case, how to handle this prior to this case coming out, but nobody quite knew for sure, and now that seems to be the rule. So if somebody lives here and has the residency requirement, they have a right to get divorced. The state can't make somebody stay married if they meet that requirement, the residency requirement here. The problem is that somebody can move here from out of state where and the other parties never lived here. So there's no real personal jurisdiction over the other party. And that was the case in this Metzer versus Metzer situation. So the only thing that the court could really do was dissolve the marriage. And the court couldn't, it lacked personal jurisdiction to adjudicate personal matters such as support or alimony. And that was what they did. They simply just granted the dissolution of marriage. And of course, this can come up in a case as well when they're not in an out-of-state situation, but maybe when the court, the children are there's children of a marriage and they are currently wards of the state through a juvenile court action, the courts will sometimes, district court will allow you to proceed and just get a divorce that does not address any custody issues because of that. And it goes to this sort of right to not have to be married in a marriage that you don't want to be in. I know this looks like it says illegal separation at first glance, but it is legal separation. And that's what we're going to talk about now. So, legal separation, the court has to make findings. And there's the statute that talks about legal separation. The findings, of course, the court has to make findings in a dissolution action as well. But unlike a dissolution action, the court does not have to make find that the marriage is irretrievably broken. They simply have to make a finding the parties shall live separate and apart. And there can be all kinds of reasons for legal separation, and the court will recognize any of those. Residency. Legal separation does not have the 1-year residency requirement of a dissolution action. So that is, I would say, the vast majority of legal separations that get filed, probably, maybe I don't know for sure, but the ones I've seen have been because of this. There needs to be some legal division, and as we will see in a slide or two, the court can enter orders, for support and all those things with a legal separation, child support and all that, temporary custody. That would be necessary, but you can't file the divorce yet, so you file this legal separation so you can start getting your child support on a temporary basis. Action still needs to be filed in the district court of a county in which one of the parties resides, but like I said, don't need to have lived here for a year. So then what happens if the intent was they want to get divorced, if during the time of if the legal separation, so my belief is that this is only while the legal separation is pending. Once an order of legal separation has been entered, and you want to get divorced, I think you need to file a new cause of action for divorce because there is a final order of legal separation. But while this is pending, and the residency requirement then becomes met, the person then has lived here for a year, they can amend either party can amend the pleadings to reflect seek a dissolution of marriage. And I believe I had a case like that once where my client did not want a dissolution of marriage and filed a legal separation and that was for religious reasons for one, but they had also not been here for a year. And then as soon as the year time came up, the other party amended their answer and counter complaint to reflect dissolution of marriage. And that's the statute 42-350. It tells you how to do that. 42-368. So when there's legal separation, the court can order support, and that's and just like in a divorce case, and orders for child support in cases where a party has applied for services under Title, so that's Medicaid, Title 4D, and then they have to comply with those statutes that are in effect for those types of cases. So it's basically, it can enter the same orders that it would in a dissolution action, even though it's a legal separation action when there's kids involved. Setting aside a decree of legal separation. Now, unlike a divorce where you can't just go in and get the divorce decree just erased, you'd have to actually go in and get remarried. A legal separation, that decree can be set aside at any time. So there's no statute of limitations on that. You can have a legal separation. 20 years later, you decide you no longer want to live separately and apart. You want to get back together, you can go in and have this set aside. And that's the statute that tells you how to do that. Annulment. That's everybody's favorite one. I've had, I think, 3 of these come up, and they've all been for the same thing, where there was a living spouse of one of the parties at the time that they got married. I haven't had any other reason come up for an annulment, but here's the procedure that talks about annulment. And they are brought in the same manner as actions for dissolution of marriage, and they're subject to all applicable provisions of dissolution of marriage pertaining to, except that this does have a different residency requirement, that it shall be the plaintiff is an actual resident of the county in which the complaint is filed. So it doesn't have the year, I think, because they want these annulments to occur as quick as possible, because it's like an abhorrence in the law here, where that these things shouldn't be in place. And so the only requirement is that the person filing lives in the county where they file. But there was a question, I don't know how many of you are members of the get the family law listserv emails from the Bar Association. There was a question about a month ago about alimony in where the proceeding was going to be an annulment, and there's comments, I think, that people thought, well, because it was an annulment, there shouldn't be any alimony. And I disagree with that. I think that this statute makes it clear, because the alimony statute is 42,369. That is within the range of 42,347 to 42,381. To me, that means alimony's on the table. And it should, it shouldn't be that some innocent spouse married somebody who didn't properly get divorced before, has stayed at home, gave up their career, raised the kids, have gave up their pursuit of higher education and their ability to earn high income, so that the other party could do that. It would be unfair then to let that person then and just say, oh, well, because this is an annulment, you don't get any spousal support or alimony. That would be a sort of a very unfair situation after so long of a time. And so my thoughts are alimony is on the table in an annulment. Here are the conditions for an annulment, and there's the statute that tells you where these come from. And these are the only reasons that you can seek an annulment. Marriage between the parties is prohibited by law. What does that mean? Well, one of the parties wasn't of legal age to marry. One of the parties was incapacitated for some other reason other than minority. And that is, or their brother and sister, whatever the case may be, that those parties are prohibited from marrying. And if the marriage has taken place, it can be annulled. This impotent aspect of it, I don't know if that really withstands the test of modern times, particularly when we have same-sex marriages where that may not likely even be an issue, or there are parties that maybe don't want to have children to begin with, when even in the same opposite sex marriage. But so that just seems like a very old reason to me, and I just don't know. I have not seen a case where that's come up in the years that I've been practicing law, either case law or anything like that. Be interesting to see what was said about that, but I just don't know if that's going to come up and how you prove that as well. I guess you're getting into some medical detail and things like that, but either party, the main one I think is either party had a spouse living at the time of marriage, and that's like I said, I've had this come up 3 times. All 3 times it's been that issue where somebody was married and didn't properly get a divorce, and that was what we're dealing with. Force or fraud, I've not seen that come up. I don't really know what, I mean, in the modern world, what that would mean. You know, forcing someone to get married. I just would hate to have to. I'd feel very sorry for someone who was forced into or tricked into a marriage, but I guess that is my understanding of what that provision means. I've not seen that. I can't see if there's any questions because I can only see my screen of stuff. So if there are questions, we will get to those in a few minutes, a little bit. I would like to know if anybody has done an annulment for one of these other reasons outside of having a living spouse. I'd be curious to know that. Disability. So if somebody has a disability and has incapacity to basically incapacity of one of the married parties, then somebody, a responsible person, an adult next friend or their parent, if they are of infancy, if that's the disability, can bring the action for an annulment, and which makes perfect sense. So here is, I'd also like to know if anybody's had this situation. 42-375, an annulment may not be decreed if the marriage is found to be voidable and the parties freely cohabitated after the ground for annulment was terminated or become known to the innocent party. I think this would probably, I can't imagine that this applies in where somebody is still married, because we do not allow people to be married to more than one person at the same time. So I believe that this has to do with more the fraud aspect of things. Someone was sort of tricked into marrying someone, maybe thinking that they were wealthy or whatever it was, and they were married. Then the spouse who thought the other spouse was wealthy realizes that that's not the case, and then still lives as husband and wife or spouses after that. Then I think that the court could deny the annulment and require a divorce to be sought, because they spent some time, maybe years after discovering whatever it was that would have allowed the marriage to be voided. But again, I don't think it applies to somebody who's already married to somebody else. I also don't think it applies to somebody who lacks capacity at the time they were married. If that, just to me, that is, if you lack capacity to do that it's not good. It's not valid. Doubted marriage procedure. So when the validity of a marriage is doubted, either party may file a complaint and the court shall decree it annulled or affirmed according to the proof. So I think this is telling you that you file a complaint for annulment. So just like if the marriage is voided out, annulled, pursuant to the statutes, the children born during that purported marriage are legitimate for all purposes, all legal purposes. You can't, unless there's other reasons that they are not legitimate, you would have to go that route that you would have in a divorce. So they're presumed to be legitimate just like they are in a divorce, and you can use the same means of disproving that legitimacy the same way you would in a dissolution action, which makes sense. You don't want to unfairly and say these aren't children of one of the parties. All right, so I ended 13 minutes early. So now we're going to ask questions. How do I go back here? We have our contact information there for our people who are wanting to seek our services, the statewide access line. If you want to volunteer to help out, there's our pro bono at legalaidofnebraska.org email. There's my contact information. I love answering questions about family law or just actually anything legal wise, particularly sort of crazy procedural things that come up in the practice, and particularly in family law. You can contact me even if I don't know you, and say, hey, I saw you present about basics, divorce basics, and I have questions about this, how to do this. I'll be glad to answer those or point you in the direction of someone who could answer your question if I am unable to. Looks like so ahead of time, some people sent in some questions. One of them was, were there anything from the legislative session that will be affecting family law? And I don't know if that is the case. I think Pat is going to talk about some of the new legislation that's coming up related to this, but isn't specific to divorce, legal separation and annulment. Somebody also asked the average time, and I think that from this, I guess the start of a filing of a divorce case till you get your decree of dissolution, and that of course is going to depend on a lot of things. One, which court and judge is handling that case, whether it's a settled case. If it's all settled, I would say for me in Lancaster County, if everybody agrees on everything, we're probably looking at 4 to 6 months. But by the time my clients get their parenting class done and come up with a parenting plan and the waiting period and that would, 3-4 months would be probably the quickest. If it's going to be disputed and there's going to be a trial, you've got to wait till mediation's been attempted, and then there's children involved. You've got to wait till mediation's been attempted, and that has failed, and then get a trial date, and prepare your pre-trial conference memorandum, Exhibit A, they call it in Lancaster County, and do all that stuff, and then try the case. And then, I tried a case in June of this year, and we got our decree in December of this year. So, and we had litigated the case for over a year prior to that. Now, that was a custody case. That wasn't a divorce, but it was a contested custody case. That was the only issue, unlike a divorce, which adds additional issues. And so that case took, close to 2 years from the time that client retained legal aid to be her attorney, and by the time we got a decree that resolved everything. And so they take a long time. They can take a long time, and when issues in dispute. Now we got about 10 minutes left. Let me see if there's any questions. There was a recent decision affirming a presumption. There's a question from one of the attendees. There was a recent decision affirming a presumption of paternity for a child born during a marriage. Would this ruling be applicable to legal separation and or annulment? Yes, I believe so. All of those, because it's the presumption of paternity. It's actually a presumption of legitimacy is what the statute says. So it doesn't use the phrase presumption of paternity. It's presumption of legitimacy. And a child born to married people, which if you're seeking a legal separation, you are married, just like if you're seeking a divorce. So it applies there. And then as I talked about, that sort of catch-all statute for annulments that says all of these apply, and that there's a specific statute that says the legitimacy of children are in an annulment situation there's considered legitimate unless there's some reason not to, just the same as you would disprove legitimacy in a dissolution action, which is having the new maybe a new father come in and testify, I am the father, also here are the paternity results. And the one, you can't just use the testimony of the two of the like the husband and wife cannot just say it's not the father's child. That's not enough to disprove to break the presumption of legitimacy. You have to have some other evidence besides that. All right, let's see. Here's another question. Oh, it's just an FYI. Nebraska Supreme Court offers non-lawyer self-help forms for family law issues. It's a good starting resource for attorneys that don't do family law often. So yeah, that is true. And so it will tell you sort of, you can look at the forms for complaint for dissolution when there's children and when there's not children. It will tell you the sort of things that need to be included in that form. And when there's children involved, the complaint needs to comply with the UCCJEA, Uniform Child Custody Jurisdiction Enforcement Act, and make all these statements about who the child has lived with, where the child has lived over a certain course of time, whether anybody besides the two parties would have an interest in the case, that sort of thing. And then that complaint needs to be verified by the person filing it to comply with that. And I believe those forms have all that information, so you can use that as a template for your own draft of a complaint for dissolution of marriage. We have about 6 minutes left. I think Pat Caraher was just going to talk about there's some new legislation being considered as far as protection orders go. And because this grant that helped provide this CLE today deals with domestic violence and helping people who are the victims, I think it'll be good to just sort of know what the legislature is considering as far as those go. So I'm going to stop sharing my screen and turn this back over to Pat Caraher.
Okay, thanks, Mark. I did want to make a couple of comments. As Mark said, someone had asked about any new legislation. And as I said earlier, our original webinars under this grant had to do with protection orders. So I think protection orders are very relevant to our discussion here today. And there was a bill introduced at the legislature on January 9th, just about 9 days ago, called the Protection Order Act. And I think it's worth mentioning just a few aspects of that because it would be significant really to anyone who does domestic relations practice. I don't know if it's going to pass or not, but it seems like a pretty reasonable bill. So I'll bet there's a good chance it does pass. Again, it's called the Protection Order Act. It's legislative bill 1098. I have it here in front of me. It's 33 pages long, so I'm not going to cover all of it. But generally, I think the first goal is to consolidate protection orders in one chapter. There are three types of protection orders. There are domestic abuse protection orders. We call them DAPOs. There are sexual assault protection orders. We call them SAPOs. And there are harassment protection orders that we call HIPPOs. So DAPOs, HIPPOs, and SAPOs are in different areas of the statutes. The sexual assault protection orders and harassment protection orders are in the criminal code, like chapter 28. But the DAPOs, the domestic abuse protection orders, are in chapter 42. Well, LB 1020 or 1098 would consolidate all of those in chapter 42. So not a substantive change, but something that I think makes sense. Just a few comments here in our final couple of minutes about some of the substantive changes that would be in this Protection Order Act. Some of this is just clarifying things that we kind of already know. For example, it says here that when awarding the petitioner temporary custody of any minor children for a period not to exceed 90 days, if the order grants temporary custody, the order shall specify the number of days of custody granted. I think some judges feel like it's either 90 days or 0. I have seen judges sometimes say 45 days, or if they know a temporary custody hearing is coming up in a divorce, they'll say however many days until that hearing. But this makes it clear that it doesn't have to be 90. that a judge could order temporary custody for as many days as they think is necessary. Another provision talks about when a judge can just out of hand deny the request for a protection order. It says if a domestic abuse protection order or sexual assault protection order is not issued ex parte, the court shall immediately schedule an evidentiary hearing. But if a harassment order is not issued ex parte, the court may schedule an evidentiary hearing. So harassment orders could be dismissed just out of hand without any type of hearing. Another change here, a protection order may be issued for an initial period of at least 1 year and no more than 2 years unless dismissed or modified. The length of the initial period shall be set at the court's discretion. Obviously now those protection orders are all maxed out at 1 year. This would allow protection orders to be put into effect for a full 2 years. And the petition and affidavit for renewal would be the same within 45 days after the expiration of the order. It does add that in a renewal of a domestic abuse protection order, if the court grants temporary custody, the renewed order shall specify the number of days of custody. I hadn't even thought about having a temporary custody order in a renewal of a protection order, but this would allow it. It also says that there must be language in the order advising the respondent that it may be unlawful under federal law for a person who is subject to a domestic abuse protection order to possess or receive firearms. I mean, that's already the case, but this would make it clear that the judge needs to advise the respondent of that. As some of you may know, there's actually a case, I think it's already been argued at the United States Supreme Court, alleging that that federal regulation violates the Second Amendment. So that may all go out the window. But if it remains in effect, then this bill would make sure that respondents in protection orders had notice of that. Hey, we are at 12:59. I do want to mention that our communications manager, Jenna Heineck, plans to send out a recording of this webinar and a copy of Mark's PowerPoint that will be sent out to all participants probably later today. And finally, I congratulate all of you because it's only January 18th, and here you already have 1 hour of continuing legal education. So thanks, everybody. Thanks, Mark. I'm going to sign off. Have a great day, everybody.
Thank you, everyone.